Good evening, everyone. I, Shivangi Sinha, Assistant Professor and Faculty Coordinator of Madhyasthta, the ADR Cell of Intra-College, Bharati Vidyapeeth, Deemed to University, Pune, welcome you all to today's session. Our guest speaker for today's session is Mr. Peter Halprin. Sir is the Policyholder Insurance Attorney, Arbitration Counsel, Arbitrator, and Professor of Law. Sir acts as counsel for US and foreign companies in domestic and international arbitrations, including both ad hoc as well as institutional arbitration forums. Sir has received as both party appointed and sole arbitrator and is a member of the AAA National Roster of Arbitrators, the CPR Institute Distinguished Panel of Neutrals, and the Singapore International Arbitration Center's Reserve Panel of Arbitrators. Sir has been recognized annually by the Super Lawyer as a New York Metro Rising Star for insurance coverage since 2013. He was recognized in the New York Law Journal as a Rising Star in 2021, and also the Expert Guides as a Rising Star in the same year. In the field of insurance and reinsurance, benchmark litigation as a 2020 New York Future Star, and the American Lawyer as 2021 Northeast Trailblazer. So today we'll be speaking on an analysis on international commercial arbitration.
So let's begin with the question and answer session. So the first question is, could you please give us a brief idea relating to the international arbitration and how it has been impacted during the period of COVID-19?
Yeah, thank you. It's lovely to be here, and I appreciate you all taking the time. It's been tremendously impacted in many different ways. I think that it has brought people together in a way like never before. I mean, I think, historically, we may not have jumped on a Zoom. We may not have thought about this as a possibility. And so as an arbitrator, I've heard applications where parties wanted to proceed remotely. I've heard applications where parties wanted to wait until the pandemic ended to proceed. Of course, it's no sign of letting up anytime soon. So that might have been quite a wait. I think it's opened opportunities for advocates so that they can participate remotely from anywhere in the world. It's reduced travel costs. It's opened up pools of arbitrators and other neutrals to participate in ADR processes who may not be geographically located in the same place as other people. I think it's had a profound change, and I'm not sure that we go back to the way it was. I think that certainly in the corporate world, businesses are excited about the prospect of continuing to use Zoom and other remote conferencing platforms, either in their business or in legal proceedings, to avoid the costs associated with travel and the associated time.
Thank you so much, sir, for giving an insightful impact on COVID-19 on arbitration. The next question is, why is arbitration important in the law? Why it is being preferred more compared to the other ADR means?
Well, I don't know if it's more preferred compared to other ADR means. I mean, I would say in the US, for example, nearly every case that occurs in our litigation system has some kind of mandatory mediation process or some kind of highly suggestive mediation process. So I think mediation is more common than arbitration as a dispute resolution mechanism kind of globally and certainly domestically in the US. But I think the reason why people opt for it and the reason why some people prefer it is that I do think it has a number of advantages over litigation. And the pandemic is a great example, right? Because if you're in a court proceeding, you may have to have regular status conferences, or you may have to follow certain normalized procedures that work for all cases. But when you have two highly sophisticated business entities, they should be able to tailor the proceedings and work with the tribunal to tailor the proceedings to their specific needs. And so I think that's a very attractive thing. Confidentiality is attractive. Being able to tailor procedures and have the right arbitrator may mean lower costs and some efficiencies over court. So there are a lot of benefits to arbitration over litigation. The flip side of that, which is really what's good about arbitration can also be what's bad, is that there's a reason why the civil litigation process exists in the way that it does, with robust protections for people. And so I think particularly where you don't have a balance in the two parties in terms of power or resources, it can be beneficial to be in that other realm, to be in a realm where, you have a true gatekeeper and so on and so forth. The arbitration process puts a lot of onus on the parties and their counsel to do things and to cooperate and to move things along. It's much easier to be a recalcitrant party in arbitration and undertake guerrilla tactics than it might be to do so in court.
Thank you, sir, for such an elaborated answer. Moving on ahead with the next question. What happens if it is alleged that the arbitrators have no jurisdiction?
In the arbitration or prior?
Yes, sir. I'll repeat the question. What happens if it is alleged that the arbitrators have no jurisdiction in the arbitration?
Right. So it depends, I guess, when and where, right? So it could be alleged that the arbitrators have no jurisdiction in what they call phase one. So questions about the enforcement of the arbitration agreement proper. You could have the same issue once you're in arbitration, what they refer to as stage two, or you could have gone through the arbitral process. Arbitrators render an award. The award then goes to the court for review, and then you can have the process kind of question there at stage three. So there are a number of different times in which jurisdiction can be questioned. And the question before the question is who gets to decide whether or not the tribunal has jurisdiction, and can the tribunal decide on its own jurisdiction? And it's a principle known as competens, or competence. And so, it will depend in what jurisdiction you're in, how exactly that will play out. But more or less, courts are okay with the tribunal assessing these issues on its own. And if you're dealing with institutional arbitration, often the institution actually provides in its rules that the arbitrator is responsible to decide their own competence. And so principles like that, I think, are pretty widely recognized internationally, though there are gradations and changes from jurisdiction to jurisdiction.
Thank you, sir, for your in-depth views. Now, moving ahead to the next question. Can an arbitration award issued by a tribunal in the United States or foreign country be enforced through US courts against assets located within or outside the United States?
So the easy answer to that question is we have the New York Convention in place, New York Convention of 1958. I think we have somewhere between 160 and 170 global signatories. So most countries are signatories to the New York Convention. And the beauty of the New York Convention is that it allows an award rendered in one jurisdiction to be treated essentially as a domestic award in some other jurisdiction for purposes of enforcement. So generally the answer is yes, and so long as the New York Convention is applicable, generally an award rendered in New York may be enforceable elsewhere in India or somewhere else, so long as all parties or all states are contracting parties in the New York Convention.
Definitely, this information will be very useful for the aspiring students. Moving forward to the next question now. Can a third party access arbitration hearings?
A third party access arbitration hearings. So generally you have confidentiality. So I think that the answer to your question is generally not. Of course, with everything, there are exceptions. Once a party goes to have an award enforced, oftentimes when they go to court, that then becomes part of the public record. But I guess generally third parties wouldn't even know about arbitrations given confidentiality.
Thank you, sir. This would definitely help our viewers to get a clear picture of arbitration. Let's move on to the next question. Can a party to an arbitration rely on a document such as an award obtained in an earlier arbitration?
I think your question is going to a kind of a concept of res judicata. So whether or not the second proceeding would somehow be barred or their hands would be tied, the arbitrator's hands would be tied by the first proceeding. It's a good question. It's a complicated question. I think that it will depend on a number of things, Generally, in the courts, to have res judicata, you need an identity or a mutuality of parties, the same parties in both disputes, and you need the issue to have been conclusively raised and decided, being the same issue in both disputes. So I think there are res judicata principles, but generally, arbitrators have wide discretion in how they render decisions. They may not even be bound by law. They may call on concepts of equity or other things. So I'm not sure that res judicata would always apply in arbitration.
Thank you, sir, for such an insightful answer to this difficult question. Now, moving to the next question. Can a company disclose information pertaining to arbitration proceedings in its annual report?
Good question. I think that it will, I'm going to be the lawyer again and say it depends. Generally, as I said, arbitration has confidentiality, so you're really not to make these things public. But giving the example that I gave of, let's say there's proceedings to enforce the award and the award becomes public, then the same protections that previously existed may not. And so I would say while an arbitration is going on, it would be very hard for them to do so. But once the arbitration has concluded and there may be something, either perhaps it's settled and there's some agreement on what can be disclosed or what must be disclosed, they may have a legal obligation to regulators or otherwise to somehow disclose the information. But generally, the starting point for the analysis would be confidentiality. And then the question would be, is there an exception that would apply in this particular instance?
Next question is, please give an overview of choice of law in international commercial arbitration.
Okay. An overview of choice of law. So generally, there's two main laws that we're questioning in international arbitration. One is the substantive law of the contract, so what law governs the interpretation of the terms of the contract, and the other is what procedural law governs the arbitration. And there, the question relates to, is there, for example, a mandatory national law or rules, or a country's adopted the UNCITRAL model law, and how do you deal with procedures? And generally, or the English Arbitration Act, generally those laws say that, number one, the parties have autonomy and can do what they want, subject to certain mandatory provisions. On the substantive law side, most contracts will specify that the governing law of this contract is X, which of course makes for a relatively simple issue. But then you can get into a more complicated analysis about, in the absence of such an express choice, what was the implied choice of the parties, or what did they mean to choose? And that'll really depend upon the potentially applicable laws, and also, if there is some guiding principle that the arbitrators need to abide by in rendering a decision on that basis. And again, that will depend widely, but I think oftentimes it will be, where are the contracting parties located? Where was the contract negotiated? Where is the contract performed? Things of that nature.
This information will be very knowledgeable for our viewers. Moving forward with the next question. When is a party bound by an arbitration agreement?
So generally, a party that signs an agreement is bound by the agreement. There's a more difficult question about non-signatories, parties that did not sign, and whether or not they can be bound. And there are certain doctrines under which that non-signatory can be bound. But generally, a party arbitration is a creature of contract. So long as someone has contractually agreed to arbitrate, then they will be so bound.
Thank you, sir. Let's move on to the last question. Where do you see arbitration as a dispute resolution mechanism in the near future?
I think it's just going to continue to grow in popularity. And I think that companies are continuing to opt for arbitration in their disputes. One interesting wrinkle, though, on that is here in the United States, there was a very large company that had a class action waiver and forced their subscribers to go into arbitration if they wanted to pursue their rights. But What happens in arbitration, which differs from court, is that there was a substantial filing fee associated with all of these cases. And all of a sudden, that company now faced, I don't know how many, at least thousands, if not hundreds of thousands of cases where they had to pay the filing fee. And because they were so upset by the fact that they had to pay millions of dollars, reportedly, this is in the news, on their filing fees, that they said from now on, we're dropping arbitration and everyone can just go sue us in court in a single class action because it will be cheaper for us. So I think people are getting more sophisticated about arbitration and they're working on better clauses. And I think the rules that are increasingly being used by the various institutions and that are rapidly changing, those are getting better and better and more robust. So I think that there's a lot of positive developments happening in the area. And I should also add that, I think diversity and inclusion has been a major focus for both arbitral institutions and arbitrators and lawyers. And I think because of those things, you're going to also see a continued push in this space to open it up and to make it more inclusive.
Thank you so much, sir, for such insightful answers. I'm sure viewers will be greatly benefited with the interactive session.
On behalf of Bharati Vidyapeeth, Dean to be University, New Law College, Pune, and Dr. Ujjwala Bindale Ma'am, Dean and In-Charge Principal, I extend my heartfelt gratitude to Peter, sir, for such an insightful session. Sir, we look forward to your guidance and contribution in our future endeavors. Thank you.